Jeffrey Lichtman for Beyond the Legal Limit. I'm back, and we're here to talk about the K. Flock case. Real name, Kevin Perez, my client, charged with murder stemming from an incident in December of 2021 in Harlem. Now, this case is pretty straightforward, although it was told two different ways up until a video of the incident was initially discovered. If you look at the press reports when this murder took place, Kevin, that's what I call him, was alleged to be walking by a barber shop in Harlem. And as he walked by the door, this is what the press reports actually say, he opened up the door, walked inside, and asked the victim, who was waiting for a haircut in the chair, what was he looking at? And then he shot the victim when the victim stepped outside to confront him. Now, initially, this shooting was described by law enforcement to be, in the media, to be gang-related. Now, again, once the video, because of course, every inch of every street in New York City is covered by someone's security camera. Once the video of the incident was discovered, it was revealed that Kevin walked by the barber shop, and the victim, who was standing at the door, not getting a haircut, not in a chair, but peering out, looking out the door, looking for something, it would appear. Well, he rushed out to yell at Kevin when he recognized him. That's what it appeared. I mean, you see it with your own eyes. Kevin waved them off and kept walking with a young woman friend who was with him. Just walked by and was like, nah, not interested. Then the victim, I hate to call him the victim because he was the aggressor, he then walked aggressively towards Kevin and the young woman with his hands in his pockets. He had one of those puffy jackets with pockets. And he was continuing to threaten them on the street, threatening them. Kevin is alleged at that point to have pulled out a gun and shot the victim twice. When the victim was placed on a stretcher, a loaded gun fell out of his pocket. So when his hand was in the pockets and he was rushing towards Kevin Perez, my client, K. Flock, well, his hand was on a gun, a loaded gun, and confirming that the threats he was making were not empty threats, I would say. Now, both the victim and Kevin are alleged by the state to be in opposing gangs, and thus the reason that the incident even occurred. So this is supposedly gang violence, according to the police. Now, the police spoke to everyone in the barber shop that day, anyone who witnessed what occurred before and after the shooting. It was in broad daylight. There are videos that were had, statements of the witnesses. The entirety of the investigation was turned over to the defense, as the state is required to by law. But they didn't turn over the names of the witnesses of the people they spoke to. And the state's position is that the defendant and people, I suppose, associated with him are so dangerous that we, the defense, should not be permitted to have these names, as they may put the witnesses in danger, which is interesting because many of these witnesses are presumably gang members themselves, as was the victim, who had a rap sheet a mile long with horrible violence in it. I don't even know their names. And we won't have our first contact with them until we're in front of the jury. They sit down, and I'm told by the judge, Mr. Lichtman, you can start your cross. And as you can imagine, this makes me uncomfortable because the witnesses who were with the dead gang member victim at the time of the shooting, presumably they're aligned with him. They're his friends. They're either in the same gang, as I said, or his friends. So common sense tells you that they're not going to be looking to do my client any favors in describing what occurred that fateful day. So you can imagine why it's crucial for me, the defense lawyer, to get my hands on the names of the witnesses so that we can determine through our own investigation whether or not the witnesses have any bias against our client or for the victim. The jury needs to hear about bias. That's an acceptable area of impeachment. How else can you determine the truth if you're a juror? You need to know exactly what incentive a witness has to lie. And you can't expect the state to tell the jury that their witnesses are liars, can you? Of course not. They're not going to do that. Now, their basis for refusing to turn over the names is, as I said, danger to the witnesses. But the law is pretty clear on this. There's a middle ground, a compromise that exists. Me, the defense attorney, can agree to not turn over the names of the witnesses to my client, to do the investigation myself with just my office and an investigator. And in this way, there can be no real claim that my client will get his hands on the names of the witnesses and do anything to intimidate or harm them, which of course is a joke as it is because he's never even been accused of obstruction of justice or even approaching a witness in this case, let alone harming or threatening them. There's no accusation. There never has been. He hasn't done a thing like that. He's been a good boy since he's been arrested. He turned himself in. He wasn't even caught. He turned himself in. So we're told that the motion for this protective order to prevent us from getting that part of the discovery is going to be made months ago.